Dan McKenzie here with the McKenzie Law Firm in Centennial, Colorado. We do estate planning, estate administration, and small business counsel. So we're in the Denver area, but do stuff in other parts of the state too. Wanted to talk today about an issue we run into with a lot of clients who are coming to us for planning. Just about every client who comes to us tells us, my goal for this is to keep it simple. I really want this to be simple. And that is certainly a understandable goal. We share that goal. The question is, what do you mean by simple? Is it simple to write, simple to come up with, or simple to actually administer when you pass away? And I think most people, when they're saying simple, they're thinking of the last one, actually. Like, I want my family to have clear instructions that they can follow, and there's really no questions that can come up about it. And so, but what's interesting is that the way, we're dealing with most people who maybe they have one or two estate plans before us. A lot of times this is their first estate plan they've ever done. So they really have not seen an estate plan before. Most of our clients haven't really been through an estate administration before. They don't really know what makes an estate administration simple. And so to substitute in what they're familiar with, they look at the length of the document as kind of a simple proxy for how easy is this plan. Is it really a straightforward, simple plan? And if they see a very long document, they're thinking, oh my God, that's complicated. Like, why is it 50, 60, 70 pages long? That's going to be really hard for someone to figure out. If they see like a 2 or 3 page document, they have the opposite. It's like, oh, well, I can read this in about 2 minutes, and it says exactly what I want to say. Like, what could be simpler than that? My wife, who is my paralegal, recently was talking with a client about this and reminded me of an exercise that I think probably a lot of people went through in elementary school, which is the teacher asked us all to go to our desks and write instructions on how to make a peanut butter and jelly sandwich. And of course, everybody goes and they say basically, get the peanut butter, get the jelly, get the bread, put the peanut butter on the bread, put the jelly on the bread, and enjoy. And that was kind of our first crack at it. And the teacher collected all those and then gathered us all in a room together. And she had the materials on the table in front of her, and she pulls out the first draft and reads the instructions that I just said. And of course, like the loaf of bread is still in the bag, and the peanut butter, of course, and the jelly are in the jar. And so she reads, take the bread and then take the peanut butter and put the peanut butter on the bread. And she grabs the jar of peanut butter and she puts it on the bag of bread, right? And we all get a good chuckle out of that. And then take the jelly and put the jelly on the bread. She does the same thing. And now we have a loaf of bread in the bag with 2 jars of peanut butter and jelly on top of it. It's like, clearly this is not a sandwich. So after going through a couple of people's instructions like that and us all getting a good laugh, we all go back to our desk. She says, now write it again and see what you can do. And of course, at that point, we all are saying very clearly, okay, untie the twist tie from the bag. Open the bag, pull out 2 slices of bread, place them on the plate. Get a jar of peanut butter, open the jar of peanut butter. Take a knife, scoop out some peanut butter, and spread it across one of the slices of bread. Very detailed instructions, right? Unlike the previous ones, took us at least several minutes to write as opposed to the 30 seconds, and a lot longer, right? So if you're using simplicity, like, okay, those first instructions were simple. They left a lot of questions to be answered, and okay, yes, it's a peanut butter and jelly sandwich. All of us are kind of, you can use common sense to figure that out. But you kind of have to do, like, you have to have common sense. You have to have made a peanut butter and jelly sandwich before to kind of know what the person meant. The other instructions really could be picked up by someone who's here from another country, another culture, never seen a peanut butter and jelly sandwich before. The goal is, here are the whole instructions. They are a lot longer. They are simpler to administer because they answer all the questions. They have all the details. So I would urge you, if you are coming up with an estate plan, to not assume that a short document is simple and a long document is complicated. So I wanted to show you an example of what I'm talking about. So I went on the internet and looked up holographic wills. If you haven't heard that term before, a holographic will is a will that is in the person's handwriting. And so here is one example that popped up. and you might be looking at this. So the text says, "I hope that you are all fine. I am not feeling well. Everything I own goes to my sister Norma. Kiss, kiss, hug, hug, Betty Williams." And so you might be looking at this. This looks like it probably was written on a sticky note, and wondering, this is not a will, right? I actually saw on Facebook the other day somebody asking about one of those online legal services, and is this really a legally binding will that I'm going to get at the end of this process? And the answer is probably yes. This holographic will, a lot of states allow for holographic wills. A holographic will is just a will where at least the material provisions are in your own handwriting. That's different from state to state. Some states require that the whole thing be in the person's handwriting and that it be signed. Not sure, this doesn't appear to be dated. I don't know if that would be important in the state where this person was, but different rules in different states, and not all states allow holographic wills, but a good number do. And so this really could be, I think the reason I found this on the internet is probably because it did get produced in a probate process and somehow became part of the public domain. But anyway, super simple, right? Pretty clear what she means to do, everything to my sister Norma. If I were going to have to put this through a probate process, though, boy, there are a lot of questions I would have about this. Don't know anything about who her heirs are, right? Did Betty have a spouse? Did she have kids? Did she have surviving parents? Did she have other siblings? Like, the interesting thing about estate planning is when we're doing the probate, we're doing the estate administration, that's a zero-sum game. Like, if a dollar goes from one person to Norma, that other person now gets one less dollar. Norma gets one more dollar. So at the end, it's all evens out, and it's $0. But the point is that if Norma is not the person who's receiving this will or would receive the estate under state law, if there were no plan, somebody else out there is getting screwed, for lack of a better term, and so they might be real interested in challenging this. So as you can imagine, it's probably easier to challenge this than a really well drawn out will that looks professionally done and all that kind of stuff. But other than that, questions of who's Norma, how old is she, does she have capacity to receive property herself? Is it supposed to be held for her in trust? Are there other, what kind of assets are we talking about? Is she just getting cash? Is she getting personal property? Are there retirement accounts? All kinds of stuff. Again, does she need somebody to hold it for her? Does she just get it? Who's doing this? Is it Norma, or is it somebody else who's going to make sure that this transfer happens? If Norma's in another state, if she's elderly, I don't really know. The note looks like it was written by somebody elderly, and it's her sister, so probably also elderly, is maybe a fair assumption to make. So I don't know if she is able to probate an estate, right? Does she have the energy to do this? So who's going to do that? Are they going to be paid? Do they get to, what kind of decisions do they get to make? If somebody challenges this thing, what powers do they have under state law to do things? I could go on and on about how hard this sticky note would be to administer. This is the least instruction you could possibly give. And in most probates, some questions come up inevitably about certain things. And so when we draft wills, I'm going to give you just the table of contents here from one that we did yesterday, right? So we signed yesterday. So this is just the table of contents. I don't know if you'll be able to read this on your video player, but if you look down at the bottom, you see a 67-page will. And this is not a rich and famous person. This is, people of, I think, fairly normal means. They've got a couple little kids. What could why would we need 67? We want to leave our stuff to each other if one of us survives the other, and if we don't survive each other, then we want to leave stuff to our kids in equal shares. That's it, right? So that's kind of what people come to us and think, and then they see this 67-page document, and sometimes they're kind of like, wow, you really made this complicated. But again, if you're the one having to administer this estate, you might be really thankful to have this level of instruction in there about, okay, how are we leaving stuff to kids who are, under the age of 10, for example? And are we leaving stuff to each other, as outright, even spouses, right? So a lot of spouses are like, yeah, I want to leave stuff to you, but ultimately when you've passed away, if I pass away first, I want our stuff to go to our kids. If you go on and get married to other people or whatever else, pick up stepkids you want to leave stuff to, you absolutely can do that with your part of what we put together here. My part, I want going to our kids, right? So, that involves some trust planning. If the kids are under the age of majority, in Colorado, when people under the age of 21 receive property, the court will appoint a conservator if there isn't already some sort of structure in place to have an adult handle that for them. And so, like you can see, if you can read this at all, like down here, there's on the second page, there's some stuff about descendants trusts, and then, it's little kids. We'll have this thing called a common trust, which just means let's create one pot of money for my trustee to be able to handle everything for those kids while they're little, just like parents do. We're not really keeping track of who's getting what. We're just trying to make sure these kids get to adulthood, and then we divide at some point. When they do reach adulthood, it's split, and off they go. And if one uses up their trust faster than their siblings uses up their trust, well, that's, you're adults now. That happens. You're out of money. Your sibling still has some. We've got this thing about a trust protector in place to just make sure if there's any questions that come up or any changes that need to be made because of changes in law or changes in circumstance, or if there's, fighting about various things, that there's somebody out there who can maybe do some stuff without having to go to court. And then we got all these instructions. A lot of people are picking family members who really haven't done this before to do the trust administration. Like I said, with the sticky note, it's like, who's doing this and what powers do they have? So we like to make it very clear, look, you don't need to be bonded. You don't need to be supervised by a court. You can be compensated for your time. Like you can, if it's a family member, we will often authorize them to do some self-dealing with the estate. Like if you want to buy the car from the estate, you can do how do you do that? What if you need to resign from this position? What if the person you've picked can't do it? Who's the backup? How do they get in there? What if the person that you've picked is doing it and then they suffer their own injury and they need to be, taken out of the process and someone else needs to step in? Like just, tons and tons of questions. And like this document, it is a heck of a lot longer than that sticky note, right? But a person who maybe doesn't administer wills every single day is going to pick it up and maybe get answers to questions. That's really our goal. They don't have to do a bunch of Googling necessarily, or maybe, we usually recommend that people do get some counsel and talk to somebody who does this all the time, but this document is meant to be a self-contained document that really does address every possible situation. And you know what? If something comes up or something does not come up that we've addressed, no harm done. If things do come up, for example, going back to the sticky note, if Norma, again, if she's elderly, if she doesn't have capacity to receive a bunch of money, or manage a bunch of money herself, like what's supposed to happen there? Like we've got all the provisions in our document for how that goes down, but that sticky note certainly doesn't, so there'd be a lot of questions to answer. So we think, in our experience, well-detailed contracts, wills, trusts, whatever it is, are just a heck of a lot easier to administer than really brief documents that just kind of say the most basic things. So again, point being, don't confuse length of document with simplicity. When you say you want your plan to be simple, you probably mean you want it to be simple for people to administer if you're not around to explain what you want. And that requires just a lot of detail, and detail requires length, and so that is not something you should be scared by. So hope this helps. If you're interested in discussing with this, if you're somehow got some connection to Colorado, we're happy to talk with you about it. Our phone number is 303-578-2745. Again, we're the McKenzie Law Firm in the Denver, Colorado area. Our website is themckenziefirm.com, and hope this was helpful, and appreciate you watching. Thanks.